Welcome to Early Returns, hosted by Jan Barron, a partner of Holtzman Vogel. This podcast examines law and politics and seeks insights from political players in elections, lobbying, media, and the law. Now, let's join our host, Jan Barron.
Welcome back to Early Returns, a podcast about law and politics. I'm your host, Jan Barron. Our producer is Jody Mayer Piazza. I'm pleased to have as my guest today Professor Bradley Smith of Capital University Law School. While he may be a mild-mannered law professor during the academic day, Brad Smith also is known as the founder and chairman of the Institute for Free Speech, which defends rights guaranteed by the First Amendment of our Constitution. He's also been a member of the Federal Election Commission between 2000 and 2005 and served as the chairman in 2004. As followers of Early Returns know, the FEC is composed of 6 members who are appointed by the president and confirmed by the Senate. The agency has no more than 3 members of any one political party, and Brad Smith was one of the 3 Republican commissioners at that time. Brad is also a graduate of Harvard Law School and has written widely about law and politics in books that he's authored, as well as for legal journals and popular media outlets. We're going to talk, he and I, about his experience at the Federal Election Commission, his academic tenure, developments in First Amendment jurisprudence, and also the founding of the Institute for Free Speech. Brad, welcome to Early Returns.
Thanks, Sean. It's my pleasure.
Well, I've given our audience the highlights of your career, but there's so much more I think you could share, particularly perhaps a little more about, where did you grow up and how did you start your path to becoming an expert First Amendment law and teaching law?
Sure. I was born and raised in an area that's known as Downriver Detroit. It's not actually part of Detroit, but they're close-in suburbs that are heavily blue-collar within a couple miles of where I grew up and where most of my friends' parents' dads worked in those days, was the Ford Motor Stamping plant where I actually worked for a couple summers and when I was a teenager. There's a Chrysler plant, there's a Mobil oil refinery, Wyandotte Chemical, a Dana plant, Dana Corporation. So that was the kind of area it was, but it was a very nice kind of upbringing. My dad was a public school teacher in the area. And in terms of, how I got into the First Amendment, we just kind of shoot ahead from that very kind of ordinary, upbringing, but a good upbringing to law school. I went to law school a little bit later in life after serving some time in the U.S. Department of State, and then went to practice law in Columbus, Ohio, which is where, though I was raised in Detroit, my family has deep roots. My mom and dad both been born in Columbus, both went to Ohio State. So I came back to Columbus, practiced with the Vorey Sater firm for a while, and decided I would like to teach, and got an interview with Capital, and that was one of the 2 jobs with Ohio State I would have been most interested in because I didn't have to move, didn't have to uproot the family, anything else. And it was kind of funny. They said to me, we want you to teach civil procedure. We want you to teach 2 sections of civil procedure. And in those days, teaching jobs were very hard to come by. And, so I told them, with all the sincerity I could muster, that I had always wanted to teach civil procedure. It was really been my life goal. And they said, and we'd like you to teach a seminar. And I said, well, what do you want the seminar in? And they said, it can really be anything you want. So I thought about this for a bit. And at that point, the one academic article I had published was an article on the rights of minor political parties, published in the Harvard Journal of Legislation. And I kind of said, why don't I teach a course in election law, which I don't think anybody did in those days. It was almost totally unheard of. So that's what I did. Oddly enough, at the time, my practice was mainly built around labor and employment law. Had they said to me, for example, we'd like you to teach labor and employment law, my whole career would have been different because I started teaching the seminar on election law and started writing. So in some ways, just kind of happenstance. And not to get too long on it, but in the fall of my first year of teaching, I wrote just a little op-ed in the Washington Times on a case that was bubbling up through Ohio called McIntyre versus Ohio Elections Commission, which would eventually go to the Supreme Court. And David Bose of the Cato Institute saw it, and he sent me a letter saying, hey, we've been looking for somebody to write on campaign finance law. Would you have any interest in doing that? And we'll pay you $1,000. And I was like a junior untenured professor, and I was like, $1,000? Yeah, So I wrote a piece for them that I eventually, some of that research and expanded into a piece that was published in the Yale Law Journal called Faulty Assumptions and Undemocratic Consequences of Campaign Finance Reform. And that sort of started the career. But a final coda on this is just a little bit interesting is, so years later, when I'm appointed to the FEC, nominated, you got to go back through everything. They want to know, every speech you gave since fifth grade and that sort of thing. So I'm going back through all these records. And what was kind of interesting to me was I found when I was in college, I went to Kalamazoo College and we had to do senior comps, which were a couple of days of full examinations. And there was one case where we had a prompt, a choice of, I think, 3 different essays. And I had written a very lengthy essay choosing one of those 3 prompts, which happened to be on campaign finance reform. This was in the fall of 1979. I'd totally forgotten about it. 20 years later, I'm nominated for the FEC. And yet, surprisingly, the views I expressed, making allowances for me being a college student and not knowing a lot, so were actually remarkably similar to what I'd concluded after years of writing and researching on the topic. So that's how I kind of blundered into the field of campaign finance and Hess First Amendment.
Wow. And this essay was in college that you discovered in your nominating experience. Is that right?
Right. Yeah.
Okay. And college was it where? Where was college for you?
It was Kalamazoo College, which is in Kalamazoo, Michigan, and small liberal arts college. And I had education there in those days.
Well, Brad, you mentioned getting nominated to the Federal Election Commission around 1999. Up to that point, you were basically just a law teacher at Capital University, although you were starting to write both in legal periodicals and in Washington journals about campaign finance. Were you involved in politics at this point in any way? Were you a campaign consultant? Were you a candidate? Were you a deep-pocketed donor to campaigns?
I'd like to say I was a deep-pocketed donor to campaigns, but no, I didn't have deep pockets. I was not, involved in politics in any real organized way. A few people knew me because I would write the occasional op-ed on political issues in the Columbus Dispatch or once in a while, so I mentioned earlier, hit the Washington Times. But I mentioned that, I had agreed to write a piece for Cato, and the Cato people got this widely distributed around Washington, D.C. And I think at the time, what I was saying was something that a lot of people kind of instinctively knew or at least felt, but there hadn't been much intellectual argument for it. And I'm going to talk about this, I hope, a bit later, but I mean, you were out there and a couple other people, in the middle of a busy law practice who would be contacted by the press now and then, but there wasn't any sort of organized effort. There were no academic studies, you might say, of people talking about campaign finance from other than the traditional, we have to regulate this is a threat to democracy, and so on. That was sort of the norm. So I think a lot of people were eager to hear that view presented in a compelling fashion with a lot of, empirical evidence and so on. Like I say, this first piece got picked up by the Yale Law Journal, and then I got known in Washington, D.C. through the efforts of the Cato Institute and invited to testify at Congress from time to time. So that's how we kind of got involved in this. And then one day in the fall of 1998, I got a call from Tamara Somerville, who was then Senator McConnell's chief of staff. And he at the time was the Republicans' point man on campaign finance. He was not in the leadership at that point, but he was their point man on campaign finance. And he said, or Tamara said to me, she said, "Hey, Brad, how would you like to come to D.C.?" And I said, "I don't really want to go to D.C. I was in D.C. earlier in my life and didn't really think it was all that great because I was pretty naive and not very smart about this stuff." And so she paused a minute. She said, "Well, would you be interested in a seat on the FEC?" So I told her that I would, or at least I certainly wouldn't rule it out. And eventually, after some further conversations with her and with Senator McConnell, we decided that the Republicans would put me forward to the Clinton White House, which would have to do the nomination, as the Republican choice for a Republican seat on the FEC. As a lot of your listeners may know, the FEC has certain seats, 3 seats for Republicans, 3 seats for Democrats. So President Clinton has to make the nomination, but by tradition, they look to the congressional leaders of the opposing party. So I was nominated eventually through that fashion. I think the word that I was the Republicans' choice didn't really break publicly until the spring of 99. And it wasn't until really, I think, if I remember right, it was early 2000 when I was actually formally nominated by the White House, which had met some resistance to making that nomination.
As I said in the intro, a mild-mannered professor from Columbus, Ohio, and you agreed to accept this nomination and move your family to Washington, D.C., if confirmed. And all of a sudden, you became the object of great controversy, and the number one critic and attacker of you, notwithstanding your limited credentials and I should say your credentials are limited to academia and scholarship work. You get attacked by Senator John McCain of Arizona, and he's kind of the leader of a very active movement in those days that went on for several years, culminating in the so-called McCain-Feingold law, where much of the public and legislative debate was about increasing the amount of regulation of campaign finance activities. So you were attacked because you disagreed, both professionally and academically, intellectually, with the goodness of overregulating politics. And because of your reasoned, well-stated disagreement, you became the object of Senator McCain's ire and scorn. So apparently it delayed your actual confirmation by a couple of years, which I understand you spent writing and then publishing a very well-received book published by Princeton University Press on this side of the argument that you represented. But what was it like to sort of enter into the public realm of criticism that was launched by Senator McCain? What was that like to you personally and your family? And then when you wound up getting confirmed, how did it affect your life at the Federal Election Commission?
So to be clear on a couple of things, as you point out, you're right, I was not a party lawyer. I had never been a candidate. I wasn't a member of even the county central committee or anything like that. I'd had no formal engagement of that sort. I hadn't been a Senate staffer or a congressional staffer of any kind. And in that respect, my nomination was kind of odd. I was plucked out and nobody in Washington knew me. So I could walk the streets of Washington as the Washington Post and the New York Times are editorializing about what a terrible guy I am. Nobody had a clue who I was. It was kind of fun in that respect. And a friend of mine who later worked in the second Bush White House told me one time we were having lunch while I was on the commission, and he was asking me, how is it you got appointed? And I kind of told him that, I just gotten to know Senator McConnell and some others from testifying and from writing. And then they'd asked me to serve on the FEC. And he said, so you were actually like a merit appointee. And I said, okay, sure. I'll take that honor as a merit appointee. So it was kind of interesting. A lot of stuff did break publicly. I remember it was a weekend in the spring of 1999 that the Washington Post and the New York Times and Al Hunt, who was the liberal columnist of the Wall Street Journal in those days, all wrote the same weekend attacking my nomination. That was the first time it really kind of became public in any way. And I remember I got a call again from a prominent Senate staffer who told me, he says, hey, you've hit the trifecta, buddy. You got all the right enemies now. There's no way they're not going to confirm you the Republican Senate majority. They just got to get you nominated. But it was kind of funny because I didn't know, I didn't even know my home state senators, Senator Voinovich at the time, and can't remember if I guess it was Senator DeWine at the time. I did not know either of them at that point. So it was kind of unusual. And, from my perspective, it wasn't so bad. I remember after those attacks began in the press, and one day Senator McConnell called me up, and he was great throughout this. He was, always restrained. But on this particular occasion, I remember he said, this is no time to get weak-kneed in his kind of way. And I said, Senator, I'm just sitting back here in Ohio. You're the one doing all the heavy lifting. I'm just sitting here reading the press. And to some extent, that was it. But I would have to say that, initially I was kind of shocked that some of the pushback I thought was as dishonest as it was. And I do think much was dishonest and distorting. Again, I was kind of naive at the time. But, in the end, it didn't make a huge difference. I had to sit down with my children at one point who were very young. And this was true later when I was on the commission as well. And I said, look, what your dad's doing important. And you may read some people criticizing him or some of your friends or something may ask, but that's because what your dad's doing is important and you don't need to worry about it. And I often would not show my wife various, press clippings or things like that. I figured she just didn't need to know. She wasn't paying much attention. But for me, it was just kind of like, watch and see what happens. It was disappointing to me, the reaction of Senator McCain in particular, because it seemed very personal with him. And he would not agree to meet with me and talk with me. And I always felt bad because in many respects, McCain was actually my kind of Republican. A lot of things he used to get flack for from a lot of Republicans were things I thought he was right on. But on this issue, we disagreed and he was having none of it. Again, he would refuse to meet with me or to talk with me, communicate with me directly in any way, but launch a number of salvos on the floor of Congress. And that was disappointing.
And that went on even as you served on the Federal Election Commission. I mean, you were confirmed by the Senate eventually. And I understand that at one point during your tenure at the FEC, you had to show up at a Senate committee hearing to testify on behalf of the FEC. And Senator McCain was there to also testify, obviously on a separate panel. And I understand that you offered to shake his hand and introduce yourself and talk to him, and he refused to shake your hand. Is that accurate?
Yeah, that was an oversight hearing in 2004 when I was chairman of the commission, and I had just had abdominal surgery, so I was actually in a wheelchair. We were having this oversight hearing, and Senator McCain was there, and I noticed he was kind of at the table by himself. And at these hearings, the first panel was he and Senator Feingold, the sponsors of the McCain-Feingold bill, and perpetual critics of the FEC. And of course, as senators, they get on the first panel, and then on the second panel is when they put the chairman of the agency. They're actually trying to investigate. And then public people, they go on the third panel because they don't really, they're just public, to take a kind of cynical view of DC. So Senator McCain was sitting there, though, by himself at the table. And I thought, this is a chance I can go up and introduce myself. We're in a public place. He'll have to be kind of, pleasant, and he'll see, I don't have fangs. I'm not a bad guy. I actually had my assistant wheel me up, and I then got out of my chair and out of my wheelchair and extended my hand. I said, Senator, and he reflexively, extended his hand. And of course, as people know, Senator McCain was horribly tortured during the Vietnam War when he was a POW, and he lost much of the use of his right arm. He can't extend his arms up above his head, but he reached his arm up as he could to shake my hand. And he looked up, and then he saw who it was, and he actually yanked his hand out of mine. And he said, I'm not going to shake hands with you. He said, I know who you are. He says, you're a bully and a coward, and you have no respect for the Constitution. And then he said something that always made me laugh. He said, I'll be civil to you, but I won't shake your hand.
Well, that must be interesting to be called a bully by Senator McCain. Well, obviously, many of those issues that were addressed by the FEC and by courts as a result of the McCain-Feingold law resulted in numerous Supreme Court and other types of court decisions that declared various provisions unconstitutional. And in the end, by the time Senator McCain was running for president in 2008, he seemed to have backed down from being in the forefront of further campaign finance reform and seemed to have played that down for the remainder of his career, although he certainly made his mark as being someone advocating extensive government regulation of political activity and association through both administrative law as well as laws regulating campaign finance. Well, mercifully, you came to the end of your tenure as commissioner and chairman, and your time in Washington expired. And I gather you left with some sense of relief that it was all over and returned to Columbus, where you continued to teach. But you also decided to start what is today known as the Institute for Free Speech. Tell us a little bit about, what that transition was like. How did you go about deciding what to do and how to organize this new organization, which is now almost 20 years old and does have a well-deserved reputation for its First Amendment activity?
Okay, so we're going to skip over the actual tenure at the FEC and get into the post-FEC life. Yeah, one of the things I noticed even before I went on the FEC, and it was actually more clear to me as I was on the FEC, was that when the FEC went into court or in public opinion, in congressional hearings, there was sort of nothing on the deregulatory side. The side of people say, hey, there's important First Amendment issues here. Hey, there are things that matter other than the sort of standard common cause narrative. And so you'd go into court and it would be, the United States of America versus, some person, some campaign candidate who'd been accused of breaking the law or something. And they'd be surrounded by a phalanx of amicus briefs from scholars and think tanks. And typically standing alone opposite them was a lawyer representing the RNC or something. Might have even been like Jan Barron or someone like that. But, the other side has this whole apparatus there to support it. And it goes beyond just being in court. They didn't know where to get witnesses when the Republicans, when they were having a hearing on this, Republicans who tended to favor deregulation, Senator McCain notwithstanding, didn't know where to get witnesses. They called me up on the FEC and asked me if I said, no, I can't really be a witness. I can't, I was on the FEC on this kind of thing. And so I felt that we needed an organization that would be a sort of a broad organization that would combine both litigation efforts and also public education efforts. And I'd given this some thought. And late in my term, a couple people came to me that I'd known just a little bit from various outside activities. And they said, this McCain-Feingold law, before this, we could work through the intricacies of the law and pretty much survive. But this is really making it very difficult to get our message out, to say what we want to say to the American people. He says, is there a lawsuit we could file? And I said, well, no. I mean, if there was a lawsuit you filed, we would have filed it. And, Senator McConnell assembled a dream team of lawyers, a great team of lawyers to challenge this law. They did a great job, but they got their heads handed to them in the Supreme Court in December of 2003. So I said, what you need is we have to start changing the climate, and you need to establish an organization like this. And they said, well, would you be willing to head it up? They knew that I was planning to leave the FEC. And I said, no, I really want to teach law. But I said, but I'll help it get off the ground. I'll help organize it, raise funds and so on. And that became, at the time, the Center for Competitive Politics. The idea of competition was kind of a hot topic right then. And so we decided that would be the name. If I remember right, I believe it was Ed Crane came up with that name. Years later, we changed it to be more reflective of what we were actually doing, which was the Institute for Free Speech, especially as our brief kind of broadened outside of pure campaign finance. So that's how the organization got started. These couple folks I knew set me up with a couple meetings with some deep-pocketed individuals. And from one of those, we got a startup grant. And from there, the organization has grown. And it's something I've been very proud of to watch it grow and achieve over the last, as you say, nearly 20 years now. We started in the fall of 2005, shortly after I resigned from the FEC.
And how big is it in terms of personnel and funding? I assume you make available some information of that sort.
Sure. We're a very small player by DC standards, but I like to think we hit with a pretty good punch. The budget's about, if I remember right, about $4 million these days, and the staff is up over a dozen. We use some, what do you want to call them, adjunct fellows and so on to do some of our work. The legal team has been growing, but I actually couldn't tell you the exact number of lawyers because it's been growing rapidly. And again, I am increasingly not involved in the day-to-day management of the organization. That's in very able hands with David Keating and Alan Gura and others.
What would you say have been the top 2 or 3 most significant accomplishments of the Institute for Free Speech in its lifetime of 18, 19 years?
One thing you mentioned earlier was that our mission is to essentially work for freedom of speech, and particularly in the area of direct political speech, and that particularly means campaign finance. But although we do work around other things, efforts to control the message and advertising and that sort of thing. But I always said, my personal sort of goal was to change the way that we think about campaign finance. And I don't know if I could say that we've done that for the society at large, but I do think in elite public opinion now, it's much more acceptable and recognized to be in favor of deregulation, to recognize that all the regulations that were put into place didn't really accomplish much. Everybody complains about the system now, but everybody complained about the system then, that we have made the system a bit more fluid for challengers, made it more open for different views. So in that general sense, I think we've done a good job of at least kind of educating elite opinion. In terms of very specific, concrete issues, obviously one of the most important was a case called SpeechNow.org versus Federal Election Commission, where we represented the plaintiffs along with the Institute for Justice. And that's the case that actually allows for the creation of super PACs. Again, a lot of people hate super PACs, but I think, I'm not going to go into it here, I think there's a very good case that super PACs really have made the system better if you get past the sloganeering and look at what they've done. And that's been very successful. We headed up the amicus effort in Citizens United. We were involved in some of the discussions on planning that suit. Of course, they had a great litigation team with Ted Olson and Jim Bopp and a bunch of guys like that. But we headed up the amicus brief on that. If I remember right, you were at the conference we had on that. And it was important because, the Supreme Court, in overturning McConnell versus Federal Election Commission and Boston versus Michigan Chamber of Commerce, both acknowledged the raw number of amicus briefs they received, but also cited to several of those amicus briefs that we very specifically had arranged. And we very specifically went out and said, we need, a group of academics to talk about the the actual history of reform and how it's really kind of all been a sham aimed at political power. We need some small business groups to talk about how they can't afford to have PACs and they can't participate in the current system. So we had very specific goals like that. And we got one brief from a bunch of former FEC commissioners to say, you guys don't have any idea how complex this regulation is. And if you did, I think you'd say this is not constitutional. And that's one of the briefs that the court basically cited.
I can confirm that I was at that amicus conference and I was representing an amicus, the U.S. Chamber of Commerce, and we did file a brief, and it was cited in the majority opinion. I also hasten to add that it was cited by Justice Stevens in the dissent as well. So I felt that I had all the bases covered, but didn't realize that I had unwittingly given him some ammunition as well.
Yeah. So those were a couple of the, the major accomplishments. Over the years, we've won, dozens of lawsuits in the lower courts defending people's rights to speak against campaign finance laws, against just efforts to silence people, to refuse, for example, of local government bodies refusing to allow people with contrary views to testify during open mic periods that are public forums. So we've had a lot of success, and I'm very proud of what we've done.
And what would be some of the cases that are pending and active today that IFAS is involved in that we should be monitoring?
Well, that we're involved in, I'm trying to think here that we're directly involved in. We've got so many right now, and I'm trying to remember where we've done amicus briefs and where we've done other briefs. We've been heavily involved, as I say, in a number of lower court cases where government entities are simply shutting down the ability of people to debate. And, what happens when you talk about, like, for example, local school curriculums or local political laws, the way people organize, the way they even find out that others are out there is often by appearing in front of these local boards when they have a chance there's usually an open mic period for the public. And instead what's happening is these school officials, or in cases other officials, are literally shouting these people down and not allowing them to testify and get that view out there, maybe opposing some element of the curriculum or something like that. So we've won a number of cases along those lines. One of my favorites was a case involving the Pennsbury School District outside of Philadelphia, again, which is, people can find the video online if you search, Pennsbury School District, and see people literally yelling at their own citizens to sit down and shut up and you're done. And it's very offensive to almost all our notions of democracy. We've played major roles in fighting for freedom of donor privacy, or contributor, or as I prefer to think of it, voter and citizen privacy. One of the things that is going on now with the successes we've had in doing away with limits on what people can spend in races and what they can contribute in aggregate amounts, much of the reform agenda has switched to forced disclosure. Now, forced disclosure has been a part of the campaign finance law for a long time. We don't really challenge the basic notion that candidates should have to reveal the sources of their campaign contributions. But what's been going on is an effort to expand this to anybody who talks about politics. So if you're involved in some group, then they want you to disclose that you joined some organization. It's almost like the 1950s again. Are you a member of the Communist Party? Are you a member of some fellow traveling organization? And then they go after your jobs and they harass these people and they try to essentially make their lives miserable. And we fought that fight in a number of fronts. We had a case, IFS, or originally Center for Competitive Politics versus Harris, when she was Attorney General of California, on donor privacy. That case, we got to the Supreme Court, but ultimately the Supreme Court chose to hear oral argument in a very similar case that was well litigated by Americans for Prosperity Foundation versus Harris's successor, Bonta. That case did a lot to establish the right of people to keep their memberships and their donations to charitable organizations private. And we were, again, I think, heavily involved in the amicus efforts on that case, but also in paving the way for that case with our own suit, which was filed earlier and just kind of got passed in the Supreme Court.
Well, it sounds like the Supreme Court is a major influence on changing constitutional principles in this field. You mentioned the Bonta case on privacy, which did strike down government demands for certain types of private information from private groups that are not political committees. And, of course, the big case that overruled McCain-Feingold and the Detroit or the Michigan, the name is so famous I can't remember it anymore. Austin, yeah. How are reformers reacting to all this? They've got to sort of change the playing field because the old playing field has been taken away, right? You can't have spending limits. You can't have more oppressive restrictions on political speech. So is the playing field now pretty much shaming groups into disclosing more about their financial supporters so they can be vilified and canceled?
Yeah, I mean, I do think that's a big part of the field. By the way, given my sort of vagueness on just what litigation we've got going now, which is, I think, kind of a mark of our success, I would tell listeners, I should tell them, you can look into what we're doing and all the many cases we have pending right now at the Institute for Free Speech website, which is ifs.org. But you're right. The shift has been toward this idea of disclosure. And again, not disclosure of contributions made to candidate campaigns, but disclosure of any kind of political activity that one engage in, using the term political quite loosely. If you talk about issues, if you say, I think somebody should be confirmed to the Supreme Court, and they want to know, what are your memberships? And then these groups are often vilified. There's at least some evidence that from time to time, they may have been singled out for negative public attention, that is negative government attention. For example, the Tea Parties were a classic example. And that's one where IFS was heavily involved in exposing what was going on to the Tea Parties in terms of the IRS, the Internal Revenue Service, was dragging their feet and harassing these groups on their ability to get their charitable registrations completed. This was after President Obama repeatedly in public speeches referred to the Tea Parties as a threat to democracy. And the IRS takes its cue from the president, I think, on that sort of thing. So there's been efforts there in that kind of public way to handle things. And in recent years, the trick has been more and more to say, well, this is like a misinformation issue and an issue of national security. Foreigners may be involved. Now, there's no real idea that foreigners are involved. It's illegal for non-U.S. citizens and permanent residents to make contributions to political campaigns or to spend money even more broadly. But this is the argument that's made, sort of national security. And it's kind of a xenophobic argument. Somebody in Britain or Canada may be a member of a group that is spending money to say that we should praise Congressman X for his introduction of a bill involving trade with Canada. This would be a terrible thing for democracy. And they go after these groups in that way. It's very misleading. And it's almost embarrassing, I say, because there's a heavy level of xenophobia to it coming from people who generally like to consider themselves the most progressive element of American society.
Well, when it comes to constitutional principles, I think the Supreme Court in particular has deferred considerably to Congress and the executive branch in regulating any activity here, or I should say almost any activity here, that involves foreign citizens. That's why we have a separate law requiring disclosure in the Foreign Agent Registration Act. It's why, unlike corporations and unions, foreign nationals are still prohibited from making any contribution to any candidate anywhere in the United States. So it is a bit of an anomaly, and it sort of underscores two things. One is that, if you inject a foreign citizen into the conversation, all of a sudden the rules change. But fundamentally, it probably shouldn't make any difference as to whether or not the prohibitions and regulations make sense. If it doesn't make sense to prohibit and regulate a U.S. citizen, why does it make more sense to prohibit or regulate a foreign national, assuming that they're not voting illegally? And of course, some local jurisdictions are passing laws that permit illegal immigrants to vote in their elections. So there's a lot of irony, a lot of inconsistency, and some would say nonsense going on, depending on how you characterize the dispute. Is it a campaign finance issue? Is it a dark money issue? Is it immigration reform? Or is it campaign finance reform? So it's really odd to see this develop in such weird ways.
Yeah, to look at sort of the oddities of it. I mean, again, a foreign citizen cannot make contributions. So a wealthy Saudi prince, can't contribute. And as you kind of raised, in the end, Americans vote, and only Americans vote, except for in these few local jurisdictions that are starting to allow in local races something else. But generally, only Americans vote. It's not bad to hear an opinion. And, it may be beneficial for Americans to hear from, the Chilean-American Chamber of Commerce that a free trade pact between Chile and the United States would be a really beneficial thing. I'm not sure that's like the worst thing in the world for Americans to hear that message, or that we're incapable of hearing it and, coming up with something else. I also laugh because, since 2016, there's been a lot about the Russians trying to influence our election. And I was kind of like, Well, of course they're trying to influence our elections. They've tried to influence our elections for since the Cold War began. They tried to make sure Scoop Jackson wasn't the Democratic nominee back in the 70s. Heck, if you don't know people, they run a 24-hour cable news station in the United States. It's called RT. Of course they're trying to influence our elections. The point is, are we going to give up our own freedoms because of this fear that some Russian front may spend $100,000 on Facebook? In the 1950s, a lot of people said, yeah, we're going to give up our own freedoms for that. And I think we look back on those days today and realize that those were not good, the McCarthy era. That was not good. It was good that we didn't really go further down that road. And I think we should get there today. And just think about things like, what does it mean for a foreigner to contribute? That means that, for example, let's say, Jeep Corporation. It's the all-American corporation, Jeep, the most American brand in the world, perhaps. Well, it's got foreign shareholders. In fact, I believe they're a majority. I believe it's now a majority foreign shareholders. So should Jeep be allowed to have a political action committee like its competitors, Ford and General Motors? Should Jeep be allowed to, lobby the government? Should it be allowed to communicate with citizens about what would be good for Jeep? If you have a Jeep plant in your community, when we talk about foreigners, I don't think people quite think of it that way. Or I remember some years ago, and this is kind of a dated analogy because they sold Verizon, the cell phone company, or the phone company was owned by Vodafone, which is a British company. Now, Verizon is headquartered in New Jersey. It employs like 40,000 people in the United States. But if you want to say, no foreign money, some of these people would say you can't let Verizon play any role in politics in the United States, even though, again, it employs all these Americans, all these other Americans who are indirectly reliant on it, all these Americans who have it for service, because its parent company was British. And I just think that's kind of foolish. But that's the kind of demagogic game that's being played now.
Well, we talked about the Supreme Court. Obviously, it has a great influence on areas of First Amendment freedoms in the cases that they decide to accept and judge. Are there any cases coming up at the court that you think we should be keeping an eye on that would affect First Amendment rights in the next term?
Yeah, I would note, by the way, that the Roberts Court has been a great court for the First Amendment. They have really been good in fighting off a lot of these efforts, not just in campaign finance, but in many avenues, and particularly in political speech. A few of the cases that I think are very important that are coming up. One of the most important, this is set up for conference in September, so we'll see if the Supreme Court takes the case. That's National Rifle Association versus Vullo. And in that particular case, Andrew Cuomo, the former governor of New York, had stated very publicly that if he could put the NRA out of business, that's what he would do. And then he directed his state director of finance, or something is the title, which oversees financial companies, insurance companies, banks, and so on, to see if there wasn't a risk to companies doing business with the NRA. So Vullo sends out guidance to banks and insurance companies saying, hey, you might want to really look as to whether you should do business with NRA, process their banking transactions, allow them to buy insurance from you, because, they're a controversial group. This might be a risk to your business somehow. Now, historically, we looked at business risk as, do you have sound business practices? Do you have adequate cash reserves? Do you, function that way? Not just what do people think about your political views or your product. And this is, of course...
This sounds a lot more like The Sopranos in Northern Jersey. That's a nice business you got there. Wouldn't want something to happen to it, would you?
It does. And it's very dangerous if you think about it, that if the government decides they don't like your business, they'll essentially kind of threaten other people, banks that are heavily regulated, with saying, hey, maybe I'm not saying we're just your regulators who can shut your business down. But that has nothing to do with the fact that maybe you don't want to do business with that guy. And if that doesn't bother you, if you're a listener, think about it. Suppose the government came to your employer and said, hey, we have reason to believe that your employee Joe is violating your company's policies. Maybe you should consider firing him. How would you think about that if the government actually came to your employer, who was maybe a government contractor, that kind of thing? So this is a very important case. And there's a couple other cases that are in the courts of appeals behind it that I think will be influenced by it. Maybe if the court doesn't take NRA versus Vullo, it's because they want to wait for another case, see more. But one is Missouri versus Biden. This is a case where a federal district judge issued an injunction against various federal officials and agencies from even contacting social media companies. Now, that injunction was stayed by a court of appeals. That's going to go up through the chain. The factual findings of the judge, the district court judge, which are almost 200 pages, are quite alarming. I mean, the government claims they were trying to stop misinformation, but really they were trying to get social media companies to take down posts that were critical of Joe Biden. They were trying to get going after parody accounts and things like that. And they would go to the companies and they'd say, we think this violates your policy. And the company would say, no, it doesn't. And the company would get a second email saying essentially, it sure as hell does. And we're making sure that top people in government know about this. And, there's antitrust proceedings going on against you, and what are those companies supposed to do? It's really quite frightening to look at that. A somewhat similar case, O'Hanley versus California Secretary of State, although there the government influence, which was from the state of California, was a bit more, shall we say, genteel. And, it raises tough questions because certainly the government has a right to speak and the government has a right to say a newspaper, hey, we think you ran an article that is wrong, that has your facts wrong or doesn't have context. We think you should reconsider it or run a rebuttal or something like that. But on the other hand, you can easily see where that becomes a kind of a bullying and a threat from the government and very dangerous to liberty. So that's one case that's up there. Another case that's the court has accepted for hearing is a case called Freese versus Formella. This has to do with criminal libel. The Institute for Free Speech has filed an amicus brief in favor of Freese. Freese did some social media posts in which he called a cop corrupt and some things, and said his daughter was a prostitute, and so some other very nasty things. Now, we have, of course, defamation laws, but in this case, the state actually has a criminal libel law, which makes it criminal to criticize certain people in the government. They went after him initially. The state attorney general, who's oddly enough the defendant now in the case, eventually got in and said, no, that's not, you guys can't arrest him and prosecute him for this. But he has gone ahead and filed a suit saying, look, this has happened to me twice now, which it has. And I'm afraid, to comment on things I should have a right to comment on, that these police officers threaten to arrest me, book me, things like that.
And what state is this?
This is up in New Hampshire. But there's about 20 states that still have criminal libel laws on the books. And again, the idea of criminal libel, of the government prosecuting you for criticizing an official, is, again, I think kind of dangerous. We do, again, have defamation laws. And I think that's where this kind of thing should more properly perhaps be maintained. Those are at least a couple areas. Another big area that's going to be coming down the pike is the social media laws, the Texas laws and Florida laws that attempt to place some restrictions on social media and their ability to limit or censor people's posts. Whose speech is that? Is that the speech of those private companies? Is it the speech of the people who are on the platforms? And there's a lot of thorny First Amendment issues in those cases.
Well, thank you for those highlights. We're certainly going to try and keep an eye on, see what the courts do. It sounds to me like you're going to be spending a lot of your time drafting and reading briefs in a lot of cases. And one of the regular features of our Early Returns podcast, when we come to the end of a conversation like this with a guest, is to find out a little more about what you might be reading other than briefs and legal products. Do you have any book recommendations for our listeners?
Yeah, well, having listened to the podcast and knowing you were likely to answer that question, I decided I was going to first mention a book that actually I read about a decade ago. But given the nature of our conversation today, it's really good reading and also relevant to our situation today. I tend to read nonfiction. And this book is a book by an Ohio State professor named Paula Baker. It's called Curbing Campaign Cash. And it's the story of the 1918 United States Senate election in Michigan. Woodrow Wilson, the Democratic president, personally recruited Henry Ford to run as a Democrat for the seat. It was an open seat that had been held by a Republican. And the Republican was a fellow named Truman Newberry, who was also quite wealthy. But Henry Ford was the most famous man in the world, had astronomical approval ratings, I think you could say, in those days, to the extent he had some ugly characteristics, such as his anti-Semitism. Most people didn't know about it, or in those days didn't care. He was also very ignorant about government. I mean, he was a man of many talents, but when he was first asked to run for senator, one of his first comments was, "What does a senator do?" So once he decided to run, he felt like, I'm the most famous person in the country and I should be able to win. And during the course of the campaign, Newberry responded by spending a great deal of money in those days. And what today would be, depending on who you believe, somewhere between, in today's dollars, about $3.5 million to $15 million to try to beat Henry Ford. And he did beat him in a very, very close race. Meanwhile, even while the race was going on, Henry Ford hired 40 investigators to research Newberry and find out if he was violating campaign finance laws, early campaign finance laws. And they presented their findings to the Justice Department, which, remember, is controlled by Woodrow Wilson, which went after Newberry with a special prosecutor. And so it's just a great story of sort of campaign finance and our politics generally, right? A privately campaign prepared dossier, right, is used to trigger a government investigation, all under this great rubric of anti-corruption, this rhetoric about how they're saving democracy and all this kind of stuff, when it's really very, partisan. And then think about it. How were you going? In fact, Ford led in one of his briefs with the argument that, of course, Truman Newberry had to violate campaign finance laws. How else could he have possibly won against a man as famous as Henry Ford? For many of us, that's the argument as to why we shouldn't have campaign finance laws. And the law in Michigan at the time would have limited Newberry to spending about, in today's money, about $75,000 in money back then, $3,750.
Wow.
And Ford was absolutely right. You couldn't win on that basis. So that's a really great book for political geeks.
Well, give us the name of the book again and the author.
It's called Curbing Campaign Cash by Paula Baker. And if I can suggest two others, one is another book that I think is just really interesting to think about our times and some of the comparisons. And this is a book, or you can read one of several, by an American historian named Stanley Payne. And I just read his book, The Fall of the Spanish Republic, which is a super book. He's written extensively about Spain. But, most Americans, to the extent they know anything about the Spanish Civil War and the lead up to it. So Spain had a monarchy. They overthrew it and had a nice democratic government. And then Franco led a fascist coup, and they spent 40 years under fascist dictatorship. There's a certain amount of truth to that. I mean, that's a very simple story, but it's not one that's by any means entirely inaccurate. But what Payne does is point out the much more complex history of the Spanish Republic, and essentially how what really kind of doomed the Spanish Republic were the people who claimed that they were trying to save it, who are always talking about we have to save democracy. And so, for example, when conservatives won the elections there in 1933, right, the reaction of the left-wing parties in Spain was to demand that the election results be nullified. We can't have the conservatives win. The very nature of the republic is to be left-wing, right? And if conservatives win, it's inherently illegitimate. And when the left retook power after elections in early 1936, they acted in a very, I can't think of a better word, so I'll just say dictatorial way, autocratic kind of way, including refusing to seat conservatives who'd been elected to parliament, just saying, oh, we're not going to seat you guys. A lot of Spaniards were left feeling like whatever their public liberties, their private liberties were in danger from the republic itself, their ability to just go about their lives and that sort of thing. So it's a really good book to reflect more deeply on what's going on in America's current divides and how people are reacting to it and how they ought to react and what might be potentially a worst case scenario. And then I have to mention one other book because this is a great August read, beach read. It comes out on August 1st. It's called The Beast Keepers. And maybe I shouldn't have mentioned it because it's written by my wife. It's a novel by my wife, Julie Smith. But I would urge people to see it. It's about a veteran who takes a job in a small area of Appalachian, Ohio, only to discover that the vet practice there services Pegasus and unicorns and flying monkeys and all kinds of other mythical beasts. And his job is to serve these beasts, taking care of both their health and to protect them, shelter them from the outside world. So that's called The Beast Keepers. It's available now on all the sites that you'd go to make purchases from Julie Fudge Smith. And that obviously is a fiction book.
Well, although there might be allegories we could pull from it, I'm sure. Well, thank you, Brad, for your reading suggestions and more importantly, for your time and insights on law and politics. I also give thanks to our producer, Jody Mayer Piazza, and to our sponsor, the Holtzman Vogel Law Firm. Enjoy listening to all of our episodes on Spotify, Apple, Google, or your favorite podcast streaming platform. Thanks for listening, and I hope you will join us again on the next episode of Early Returns.
Thanks for joining Early Returns, Law and Politics with Jan Barron. We hope you will join us for future episodes, which will continue to bring you voices and insights from the people engaged in our political landscape.